XRP lawsuit sees biggest twist yet as recent Supreme Court ruling supports Ripple's fair notice defense. Welcome to the Crypto God channel. As this video concludes, my hope is that you've enjoyed it, and if you did, make sure to give it a thumbs up. Subscribe to our channel and don't forget to press the bell icon to stay notified about our uploads. I'll see you next time. Until then, peace and blessings. First off, what is the Ripple vs. SEC case? Now on to the article. Covering the U.S. Securities and Exchange Commission's, SEC, ill-conceived enforcement action against San Francisco-based blockchain company Ripple is never dull, and Friday offered yet another development in the suit. Since late 2020, Ripple Labs, the creators of the XRP token, has been locked in a legal battle with the United States Securities and Exchange Commission. The big question is whether or not XRP is a security. In court documents, Ripple argued that the recent U.S. Supreme Court ruling in Bittner v. United States buttresses their fair notice argument. On December 22, 2020, the SEC filed a lawsuit against Ripple Labs and two of its executives on the grounds that they traded $1.3 billion in their XRP token as security without registering it with the commission. There have been arguments for and against the lawsuit. However, Ripple has strongly countered the claims, arguing that the SEC has been biased in its assessment. How Supreme Court ruling bolsters Ripple's defense. Ripple on Friday filed a supplemental letter in the U.S. District Court supporting its motion in the ongoing lawsuit with the SEC. Ripple noted that the Tuesday Supreme Court verdict in the Bittner case, which restricts the government's ability to impose penalties on American taxpayers who do not report foreign bank accounts, stressed that the SEC failed to provide fair notice prior to bringing its enforcement action. The SEC uses the Howey test, based on the Supreme Court ruling on SEC v. W.J. Howey Company in 1946, to determine whether a cryptocurrency is a security. An asset is considered a security if it is sold with the expectation of getting profits from the efforts of other parties. Based on the Commission's definition of XRP and its lawsuit, the cryptocurrency would pass the Howey test, and according to SEC regulations, all securities must be registered. The Supreme Court stated in the Bittner case that a fair warning should be given to the world in language that the common world will understand, of what the law intends to do if a certain line is passed. Throughout the pre-trial phase of the SEC v. XRP lawsuit, Ripple's lawyers established that the SEC denied fair notice not just on XRP but crypto assets in general. When Ripple filed its intent to submit a fair notice defense, the SEC launched a series of frantic filings to try and stop the company. The court, however, later permitted Ripple to explain its fair notice defense. While most companies targeted by the SEC in a similar matter chose to settle, Ripple decided to fight. The outcome of the lawsuit will undoubtedly have far-reaching implications in the crypto space. If Ripple prevails, the SEC could lose some of its credibility, giving other crypto-based companies the confidence to revolt. On the flip side, if the SEC wins the case, it could upend the way crypto firms operate and usher in a new wave of registration rules that apply to securities. This particular defense argues that the SEC did not notify Ripple that its actions violated the law before it took legal action. The firm contended that the American top financial cop failed to formulate a clear framework for the fast-growing crypto industry relating to the application of securities laws, thus causing regulatory uncertainty in the market. Ripple has asked presiding judge Annalisa Torres to consider the Supreme Court decision at the time of ruling whether Ripple, along with its current and former CEOs Brad Garlinghouse and Chris Larson, respectively, broke the law by raising over $1.3 billion after selling the XRP cryptocurrency as unregistered securities. Will Ripple beat SEC in court with groundbreaking update? Founder of crypto legal news outlet Cryptolaw Johnny Deaton, who is also amicus curiae in the XRP suit, recently spoke about the market onlookers speculating that Ripple filed this letter now because they know the SEC will prevail. Deaton notes that the U.S. Supreme Court ruling came just 4 days ago. He claims that this court decision corroborates Ripple's assertion that the lack of fair notice breaks the Due Process Clause of the United States Constitution. If District Judge Torres decides that Ripple sold XRP as an unregistered security, this recent Supreme Court ruling gives the company's fair notice defense a few more teeth. According to Deaton, the attorney reiterated his belief that the current Supreme Court would rule in Ripple's favor. While the West Virginia EPA lawsuit alone is reason to believe Ripple will ultimately win the drawn-out legal battle, the latest ruling from the Supreme Court is the proverbial cherry on the sundae for the company's case. Judge Torres is expected to make her decision on the lawsuit any time now, but it can extend to 2 months. That said, if the judge executes the summary judgment, the court ruling will have a serious influence on determining which cryptocurrencies should be classed as securities under U.S. federal securities laws. That wraps up this video. I hope you enjoyed it, and if you did, Make sure to give us a thumbs up. Subscribe to our channel, and don't forget to press the bell icon to stay notified about our uploads. I'll see you in the next one. Until then, peace and blessings. Happy investing.